Welcome, valued listener. Now, the subject matter of today's lecture will be abusive discrimination. That is a form of abuse that is very badly understood and essentially is not applied, partly as enforcers don't really understand how to apply it correctly. Now, if you're uncertain about something, it is always prudent to be hesitant. But non-application can also mean that there are under-enforcement, and that is equally undesirable. And therefore, we need to discuss how to deal with abusive discrimination properly. Now, if you look into the treaty, there's absolutely no doubt that one of the provisions or one of the prohibitions on the book is that dominant undertakings are not allowed to engage in discrimination, and we even got the text outlining how to identify such an abuse. The problem is that it is very badly understood, and therefore, as I've already indicated, are enforcers very likely not really to engage in discussing if it is abusive discrimination. That can create under-enforcement. We even got a couple of examples where discrimination has been clouded in other forms of abuse, and even when it is actually applied and used, sometimes it is used in a manner that can create confusions. So in order to understand how to deal with abuse discrimination properly, we're going to structure the lecture into 3 parts. First, we're going to look into why an undertaking actually would engage in discrimination. We're going to look into how this discrimination would look like. And then finally, we're going to look into how to treat it legally. Now, the first thing that is essential to understand is that technically, an undertaking doesn't really have any incentive to discriminate its customer. So therefore, assuming that the company is rational operated, it will in principle not engage in discrimination unless it has an objective reason for that. So currently, let's just work on the assumption that discrimination is non-objective mistreatment. And then we're going to go much more into detail at a later stage. Linking the notion of discriminatory abuse to the lack of an objective justification is actually quite important, because quite often there is actually an objective and rational explanation for why a company will offer some customers better terms than others. I have a video outlining how company price, and I think it's the most excellent video, and I really recommend watching it. It's also available here on the channel. But I'm just going to give you a few highlights from that video, because the main point is that company is going to try to target or take into consideration the consumers or the buyers' willingness and ability to pay. Because everybody has a different willingness, and you don't have to be a shopaholic to be willing to pay a premium for a product, nor do you have to be a Meissner to be unwilling. It's very much individual, depending on preferences and interest, and of course also your income. And the company is going to try to identify and take this into consideration when they price. This differentiation between customers and companies in terms of what they're willing or able to pay actually explain why we have this negative correlation between price and demand, which transcends into the downward sloping demand curve. If the price is high, only a few gonna buy. If the price is low, a lot gonna buy. So companies are confronted with this downward sloping demand curve, and they have to make a decision on how to price their products. Because companies do not price randomly. You might think that, but that is actually incorrect. There's a quite advanced theory that actually explain how companies try to profit maximize, taking cost and demand into consideration. I have a separate video outlining how company price take into consideration cost and the market. In principle, there is an optimal price. I have marked it here. That is where the profit is maximized, taking consideration the cost, the market and revenue, and the downward sloping demand curve. Now, there's a couple of qualifications for that. First of all, the company cannot price differentiate or discriminate, and the company has a level of market power. If those two conditions are met, this is the price the company is going to choose. The problem of this price is that there is a lot of profit that is foregone. I have tried to illustrate it here with the colored squares. As you can see, this is profit that the company is missing out on because it cannot price differentiate. How can the company capture this? Well, if they somehow can separate the customers through different kind of selective discount classes, etc., then it's actually able to increase its profit even more. And that is why companies have a strong incentive to discriminate. That could be, happy hours. That could be, coach economy, premium economy, business class, or first class, as you will see on planes and to some extent on train. It can even be on buses, where you do actually from time to time see what we can call luxury buses, even though buses generally are considered a much cheaper alternative to planes and trains. And the whole point is that everybody has this individual willingness or ability to pay, and the company really want to target that, and therefore they will engage in what look like discriminatory practices, that is offering discounts or different kind of incentive, so they can sort of separate the customers. Now, this is very important because this has direct policy implication. First and foremost, it is too simplistic just to say that it is abusive discrimination if you offer different terms. And it is also too simplistic to just assume that discrimination is fundamentally bad, because it might actually enlarge the market. Customers who would be unwilling to pay the full price, they might actually be willing to buy the product or the service if they are offered discounts. And the complex process is, of course, to keep these customers separate. So only those who are unwilling or unable to pay the full price gets the discounts, while those who are willing to do that pay the full price. Now, a typical way of doing that is just simply to offer different kind of discounts or classes, as we would say, at a plane. This also explains why most economists are generally unwilling to condemn price discrimination per se, either because it is benign or actually pro-competitive. An interesting and important observation, because most lawyers would probably have the opposite position, seeing discrimination as something fundamentally bad. In terms of policies, we need to be very careful drawing a clear line between pro-competitive, anti-competitive, and only condemn the latter. Now, the problem is obviously that is not very easy, as I shall explain later. Having established the fundamental with respect to motive, we can start looking into and discussing what we should look for. That is, how does abusive discrimination look like in practice? And here, a lot can actually be extracted directly from Article 102, who define it is discriminatory to apply dissimilar condition to equal transaction, and by virtue of this essentially establishing how discriminatory abuse can be price or non-price and come in different variation. Now, as I said initially, a rational operator doesn't really engage in discrimination unless they have a cause for that. So we need to look for that cause. And we also need to understand that just the fact that they are not offered identical terms, or they are actually offered identical, does not imply discrimination. There had to be an ability to talk competition. And that is actually the magic word, and we're going to come back to that later. From the text of 101, that the dissimilar condition must be offered a trading partner, but case law has actually developed on that. Hoffmann-La Roche and Michelin 1, two classic abuse cases, actually involve discriminatory discount offered to a customer as required by Article 102, but directed at excluding a competitor. So even though the discrimination was vertical, the anti-competitive effect was actually horizontal. I think this requires some explanation. If we look at the text of Article 102, we can actually see how abusive discrimination are defined. The text of Article 102 refers to a situation where you have a dominant undertaking who has, in this case, two customers, customer A and customer B. And then customer A is offered better terms, which create a situation where customer B is foreclosed because its end prices are no longer competitive. Case law has taken this to another level because quite often the dominant undertaking might have a smaller competitor that they want to eliminate. Returning to our example with two customers, customer A and customer B might also be trading with a small competitor that the dominant undertaking wants to eliminate. And one way of doing that is offering customer B very attractive terms for the sole purpose of creating artificial loyalty and deny the competitor access to customers. So what we can see is that the case law has actually included an extra form of discrimination where the discriminatory practices might be vertical, but the anti-competitive effect is horizontal. Case law has also provided for a situation where the competitor who is to be excluded is not an upstream competitor, but actually a downstream competitor competing with a subsidiary or the dominant undertaking's vertically integrated downstream operation. Once again, the subsidiary or the division are offered better terms, and the competitor to the dominant undertaking is excluded. Now, in this situation, is not upstream, as we saw in Michelin and Hoffmann-La Roche, but it is a downstream competitor. However, in both situations, the discrimination is vertical, but the anti-competitive effect is actually horizontal. What we can see is how case law has actually extended the reach of Article 102 beyond the textual framing. The textual framing of Article 102 when it comes to discrimination is limited to situation where dominant undertaking discriminate between two customers downstream. The economists will call that second line discrimination, but case law has actually included an additional form of discrimination where the dominant undertaking might actually be discriminating downstream, but the object is actually to foreclose the market either upstream or downstream by excluding a competitor. The economists will call that first line discrimination. I'm going to come back to the legal words for these. But what is interesting is that where the dominant undertaking is not vertically integrated, that looks a lot like something we can call real discrimination. And the situation where the dominant undertaking is vertically integrated, or try to just simply exclude a competitor upstream and downstream, that is simply a traditional form of exclusionary conduct, which we have a pretty good idea about how to treat legally. Okay, now we're going to come to the part that you've all been waiting for. How do we treat discrimination legally? The basic for defining abusive discrimination can actually be extracted directly from Article 102, which essentially defines it to be abusive to applying dissimilar condition to equal transaction. So conceptually, discrimination can be price and non-price based, and we can have a situation where we have two customers who are identical, and therefore they must also be offered identical terms. But we can also have a situation where the two customers are not identical, and therefore they must be offered different terms. This approach has been confirmed in classic cases as Hoffmann-La Roche and Michelin 1, both essentially establishing that abusive discrimination is the non-objectively based application of dissimilar condition, or failure to do that somehow thwart competition in a downstream or upstream market. Unfortunately, these early cases also establish some misunderstanding, and that is essentially that the dominant undertaking must offer all customers similar, for good or bad, condition, and any discounts or discount program must actually be adjusted to accommodate that. Now, an example of this is the case that we all know and love, Post Denmark 1. That was a national case decided in 2004, where the National Competition Authority had taken issue with two elements. New customers has been offered better terms, which was held discriminatory and loyalty-inducing, because the object was actually to exclude a competitor, but at the same time the discount also had the ability, allegedly, to thwart competition between the customers. Now, this is actually a correct application, but the problem or the flawed part of the national decision was that there was no effect analysis. So the National Competition Authority has just simply assumed and concluded that it was anti-competitive and abusive solely against the discriminatory elements. Now, the case ended up before the Court of Justice, which obviously had issues with the line of reasoning, and that actually resulted in that wonderful ruling Post Denmark 1. So I suppose there was an element of good things in it, but it cannot overshadow the fact that the National Competition Authority had misunderstood and misapplied the fundamentals. Now, this has been corrected in subsequently case law. In one of the Deutsche Post case, the Commission essentially held that discrimination is only abusive if it is capable of distorting competition by creating a disadvantage. Now, this is also what is outlined directly in Article 102, but case law, as we have already discussed, has been slightly hesitant to really apply that in practice, creating the misunderstanding that unfortunately, or we could perhaps say luckily, created this wonderful case that we all know as Post Denmark 1. Now, this Deutsche Post case is actually a real jewel. It is a hidden jewel, we very rarely see any references to in the literature or in cases, but it truly outlines how to approach a possible discriminatory abuse. because the Commission here actually explains how Article 102 covers no less than 3 forms of discrimination. And these 3 forms of discrimination are actually concepts that we know and have an understanding about, because even though there are 3 forms of discrimination, 2 of them are exclusionary and 1 is exploitative. What makes this so wonderful is not only that we now understand that there are 3 forms of discrimination, 2 exclusionary and 1 exploitative, but also that we use or we see references to concepts that we understand. You know, exclusionary conduct is something that has been a lot of cases about, and we have essentially reached a level where we normally don't condemn exclusionary conduct unless it is able to foreclose an equal efficient competitor, or another way, be destructive. So we do actually have an idea how to treat the 2 first forms of exclusionary conduct. And with respect to the exploitative, it is essentially excessive pricing, as I shall explain. The reason why we know how to treat exploitative discrimination is because it is a well-established concept. The economists would call it perfect price discrimination, and here the dominant undertaking are able to price its product or service in accordance with each customer's individual willingness or ability to pay. By this, it can maximize the profit. We would also be inclined to call this excessive pricing. And we will rarely see this in practice because typically the dominant undertaking cannot identify the customer's individual willingness or ability to pay. And even if it could, it cannot actually apply a price that would take this into consideration. Now, it can do it indirectly through happy hours, premium product and discount, but that is not perfect price discrimination. Now, returning to the Deutsche Post case and what the Commission actually established, we can see how there was 3 forms of discrimination, 2 exclusionary and 1 exploitative. Now, let's simplify things by cleaning up the text. So we only focus on how these 3 kinds of discrimination looks like. Now, let's start by discussing the 2 accounts of exclusionary discrimination. Here, the Commission said that there was essentially 2 kinds of exclusionary discrimination. One, where the victim was a competitor of the dominant undertaking, and one where the victim was a competitor of one of the customers. Now, first we're going to look into the first situation. That is where the victim is a competitor of a dominant undertaking. Here, the dominant undertaking is trying to eliminate a competitor. This competitor can either be upstream or downstream, depending on if the dominant undertaking is vertically integrated. If it is vertically integrated, the competitor is trying to eliminate can be downstream. And once again, we can see how the discrimination might be vertical, but the effect is horizontal, and we can therefore call this horizontal exclusionary discrimination. Now, if we then turn to the second account of exclusionary discrimination, this essentially covers a situation where the dominant undertaking is trying to eliminate a customer. This is a situation where the dominant undertaking is not active downstream. It is neither vertically integrated or has a subsidiary. We call this vertical exclusionary discrimination. From this emerges that the main difference between the 2 accounts of exclusion discrimination is who are the dominant undertaking trying to exclude. If the dominant undertaking is trying to exclude a competitor upstream or downstream, we call it horizontal exclusionary discrimination. Here, the discriminatory actions are vertical, but the effect is horizontal. Another situation is where the dominant undertaking does not have any interest downstream, but nevertheless it chooses to engage in a discriminatory behavior between customers. We call that vertical exclusionary discrimination, and here effects and actions are vertical, and we can also call that real discrimination. Now, ignoring the question about a motive or the lack of motive for the moment, it is interesting to see how in reality only one of these forms of discrimination would qualify as what we normally would call discrimination. The other one is essentially a form of price squeeze. Now that could be market squeeze. And this probably also explains, as I said initially, that we very rarely see real discrimination cases, because when it comes to engaging in vertical exclusionary discrimination or real discrimination, the dominant undertaking doesn't really have any incentive for that. And when it comes to horizontal exclusionary discrimination, then the dominant undertaking might very well have an incentive, but quite often the case will be advanced against a different theory of harm. That could be, for instance, market squeeze, or, as we've already also seen, predatory pricing. Now, having concluded that both account of exclusionary discrimination is essentially exclusionary conduct, we need to discuss how much competition must be thwarted before we would accept that an abuse has been committed. Now, the text of Article 102 demands that customers suffer commercially, but case law has been slightly ambiguous when it comes to actually implementing this. However, we have already concluded that when it comes to horizontal exclusionary discrimination, that is essentially a traditional form of exclusionary conduct, and we therefore have principle for assessing this. We therefore start by discussing horizontal exclusionary discrimination. As already indicated, the abuse should only be accepted if there is a real foreclosure risk. Having established that horizontal exclusionary discrimination is essentially just exclusionary abuse, we do actually have principle for evaluating this. Case law has progressively established a legal standard where we only see an abuse if the price does not allow an equal efficient competitor to remain in the market. Now, the efficient competitor test is developed and applied for price-based abuse, but we have cases that says that it also has relevance outside of that. Obviously, you cannot apply it directly, but the principle. And that means that horizontal exclusion discrimination, which essentially is just exclusionary conduct, is only to be seen as abusive if it does not allow the victim, that is the competitor upstream or downstream, to remain in the market. Typical, the as efficient competitor test would be applied in a matter where we look for the victim's long-run average incremental cost. So the upstream price shall not allow the victim, downstream or upstream, to remain viable because it doesn't allow it to cover its long-run average incremental cost. When it comes to vertical exclusion or discrimination, things becomes a little more complicated. We don't really have that many cases, or we don't really have any cases that we really can rely on in terms of extracting clear principle. And that is easy to understand because, as we have discussed, the dominant undertaking who are not active downstream doesn't really have any incentive to engage in discriminatory abuse. Now, it does have an incentive to try to target the customer's individual willingness or ability to pay, but that is not exclusionary. It might be exploitative, but that is something different, and we will talk about that in a few minutes. We have one case that does offer a little guidance, and that is the Mayo case. Here, the Court of Justice was actually specifically asked for guidance when it came to vertical exclusionary discrimination. Unfortunately, the court declined to provide any guidance beyond the need to establish a distortion. If we take the principle from the Mayo case and combine it with another interesting case, we actually get some principle we can work with. In the Portuguese airport case, the Commission took issues with a policy at an airport under which domestic flight operator got much more attractive terms in terms of pricing than non-domestic operator. We don't have a full effect analysis in the case, but we can see how there was a huge difference between the terms, and taking into consideration how flight operator often operate on the margin, it is highly plausible that this was actually distortive downstream. That means that we can actually suggest using the long-run average incremental cost standard as benchmark. And the reason why I suggest doing that is, had the dominant undertaking been vertically integrated, that would actually have been the principle we'd be using, either because it was a margin squeeze case or because it was horizontal exclusionary discrimination. So it makes sense to apply the same principle to vertical exclusionary discrimination and essentially add to which extent the term allow a competitor, that is the victim, to cover its downstream long-run average incremental cost. Now, thinking out the box for a moment, I think there are two practical observations that need to be shared and understood when it comes to vertical exclusionary discrimination. We already touched upon one of them. That is that the dominant undertaking doesn't really have any incentive to discriminate between customers, and therefore we don't really see real discrimination very often. But there's also something else that is actually easy to understand if we think more carefully about it. That is, not only does the dominant undertaking not have an incentive to engage in vertical exclusion discrimination, it might actually have a strong incentive not to do it, because if it do, it will create a strong incentive to the victim to turn to a competitor. And in a situation, if there are no real competitor or only marginal competitor, the dominant undertaking would actually create a unique opportunity for these small competitors to grow, because the dominant undertaking are, by virtue of its discriminatory practice, essentially driving the victim of its pricing forward the competitor. So therefore, a dominant undertaking who are operating rational not only lack an incentive to engage in vertical exclusion discrimination, might actually have a very strong incentive not to do it unless it is enjoying a legal monopoly or in other way being super dominant. This probably also explains why it is so rare that we see real discrimination cases. And the cases we have cited, that is the Deutsche Post, the Portuguese airport, and the Mayo case, has all pertained to companies who enjoy different level of special rights. So there are actually very good reasons why we very rarely see vertical exclusionary discrimination, or, as I've already said, real discrimination. Returning to the Deutsche Post case, we recall how the Commission said that there was 3 kinds of discrimination, 2 exclusionary and 1 exploitative. We have now accounted for how to treat the exclusionary part of it, and we need now to discuss how to treat exploitative discrimination. Cleaning up the text, we can see how this involves practice where the customers suffers commercially in such a way that they can no longer compete effectively in a market. We have already seen how this looks. The economists would call that perfect price discrimination, and essentially it involved that the dominant undertaking managed to price accordingly to the customer's willingness or ability to pay, thereby can maximize its profit at the expense of the customers. Now, in the Deutsche Post case, the Commission cited a number of cases, but all of these are essentially ones involving national-based discrimination, which also means that there are not that many cases, and there are obvious reasons for that. And that is, of course, that even though a dominant undertaking might be very interesting in engaging in perfect price discrimination, they are typically not able to do that. First of all, customers don't really tell their price willingness, and even if they have an idea about that, it is not really possible or feasible to separate the customers. Now, I do have a feeling that if I go to an online booking agency and type in a flight connection several times, the price goes up. Now, I have not tested it sufficiently time to really establish a clear basis for that conclusion, but I do feel it. And I have also discussed it with others, and I'm not the only one. So it does look like we have some online example of companies trying to engage in price discrimination based on demand. And I think that going forward, this is something we're going to see much more example of, because traditionally it has not been possible to engage in perfect price discrimination or price discrimination at all, except for some very, rudimentary and simple examples like, discounts or happy hours, etc. But the internet and the Internet of Things makes it so much more easy to identify the customers and make a profile and perhaps even actually identify their willingness to pay. The European Commission actually submitted a note to OECD in 2018 where they actually saw a need for looking into it going forward. So, correcting my former statement, exploitative discrimination is something that in practice has been related to national-based discrimination, but going forward, I think we might see some example of individual pricing where the enforcers try to label this as exploitative, either exploitative discrimination or just simply excessive pricing. Now, case law doesn't really support the Commission's position directly, because we got a couple of old cases that essentially says that taking demand side factors into consideration, that would for instance be the willingness to pay a premium for a premium product, is not considered excessive, and by this it would neither be considered exploitative discrimination. Now, granted, these cases are old, United brand predated the internet. But before the Commission can advance anything, they would have to take these into consideration. And that means that it is not obvious that exploitative discrimination is abusive. There has been a couple of opportunities with the Commission to correct this. The first came about in 2005 when the Commission put out its discussion paper and later its enforcement paper. Here, the Commission actually promised to provide guidance pertaining to discrimination and exploitative practice, but they never delivered on that. Take into consideration all the noise that was created by the discussion paper and the enforcement paper. It's easy to understand why the Commission chose to negate on its promise, but it remained most unfortunately. Going forward, the next chance to correct the misunderstanding or put out guideline was actually in a case involving Amazon buy box. The Commission closed it against commitments, and therefore they never really had to explain the theory of harm. But looking at it, it's obvious that this is discrimination. Once again, the Commission missed this opportunity, and hopefully they will not do that next time. But luckily, I have an excellent paper about how to treat discriminatory abuse. I can recommend it. I think it is very good. And here I actually outlined the principle that I have gone through in this presentation. The presentation is also largely based on this paper. As always, the cases that I have relied upon are listed here. And should you have any comments or questions, feel free to reach out. My email is listed here. I'm always interested in hearing from my viewers and discuss competition law related matters.